This offense date was June 1st of 2012. That's 11 years and 4 months before Mr. Hinojosa was arrested on this charge.
All right, we're here on a motion to set aside the indictment based upon failure to afford and violation of constitutional right to speedy trial. State, have you reviewed that motion?
Yes, Your Honor, I have.
All right, and are you prepared to proceed?
Yes, Your Honor.
All right. Defense?
Yes, we're ready, Your Honor, and I've outlined the relevant timelines in the motion itself. And if you'd like, I can outline those. I believe that once I do outline those timelines, the burden would shift to the state. And I believe, and I don't want to speak for the state, but I believe they have one witness to put on.
All right. Then if you'll outline your reasons.
Your Honor. Briefly, the timeline before the court, and it's all available to be verified on the Bexar County information system that's available to the court. This offense date was June 1st of 2012. That's 11 years and 4 months before Mr. Hinojosa was arrested on this charge. If you look at those dates that are outlined, there are two relevant dates, both of them multiple years at a time. From the offense date to the action that the state took in August of 2017, that's a 5-year delay. Mm-hmm. From August of 17 until his arrest on this indictment is a 6-year and 2-month delay. And I'm not even including the 3 months between his arrest and today's date, which that's an additional 3 months. Your Honor, believe that the length of those delays taken together or even individually is so prejudicial that it affects our ability to put on a defense in this case in violation of the United States Constitution, the Confrontation Clause, and the Barker v. Wingo case, and as outlined in the motion, and also the Article 1, Section 10 of the Texas Constitution. I'm not sure what evidence the state has that can surmount those prejudicial delays, but that is the relevant timeline, Your Honor.
All right. All right, state.
Your Honor, I have one witness and I have arguments. You want to hear from the witness first?
Yes.
Okay, Your Honor, state calls Deputy Angela Alvarado. Yeah. So.
All right, if you move this way.
Oh, sure.
Right in the middle, Judge?
Yes, is that okay if I'm right here, Judge?
Yes.
Okay.
Can you raise your right hand for me, please? Yes, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Deputy Angela Alvarado.
All right. So everyone, you all need to whisper. If you can't whisper, then you need to confirm.
From the very beginning, this isn't just another court motion. It's about the constitutional right to a speedy trial. Think about it. 11 years have gone by since the alleged crime. 11 years. In the legal world.
All right, state.
Hi, Deputy. So did you attempt to make service of a warrant in this case?
Yes, sir. It looks like on the first attempt was January 23rd of 2019.
Okay. And then did you attempt to serve that warrant on another date as well?
2 days later, sir.
Okay. And so on January 23rd, 2019, where did you go to serve the warrant?
The address I have.
Okay. And did you have any interaction with anybody there?
I noted that I spoke with the uncle.
And, but were you able to serve the warrant on the defendant, Mr. Hinojosa, at the time?
No. I was advised that he didn't live at that location.
Okay. And so what happened a couple days later on January 25th, 2019?
I went to a secondary address on that date, his work address.
Okay. And were you able to serve the warrant on that date?
No, sir. I was advised that he used to work there, but quit the year before.
Okay. And did you try to serve the warrant before 2019, in 2017?
No, sir, that would not be me.
Okay, that was a different deputy.
Right.
So you were unable to serve the warrant on Tristan Hinojosa, but you attempted to serve it on January 23rd, 2019 and January 25th of 2019.
Yes, sir.
Okay, I pass the witness, Your Honor.
All right, defense.
Your activity in this case is limited to those 2 days in 2019, correct?
Correct.
Did you take any other action in these 11 years and 4 months between the alleged offense date and his arrest in this case?
Just beside the two dates listed on the warrant itself.
And those 2 dates were almost 2 years after the indictment, correct? A year and a half? Your 2019 attempts?
Okay, I'm not sure when.
I'm sorry, I didn't mean to interrupt you.
No, I'm not sure when the date of when he was arrested. Is that what your question was?
No, indicted.
Oh, indicted, I'm sorry.
Okay. You're not sure?
No, sir.
Pass the witness.
No other questions, Your Honor?
All right. Is this witness excused?
Yes, Your Honor.
All right, thank you.
Thank you.
Thank you.
Defense? I'm sorry, state any further questions?
I just have argument, Judge, at this.
I'm sorry, any further witnesses?
Oh, no, Your Honor.
It's Monday for me.
Yes, ma'am.
Okay. All right, then the court will hear argument. Defense, it's your motion.
Yes, Your Honor. If you look at the Barker v. Wingo factors as the courts apply them in the state of Texas,
The defense highlights a 5-year delay, followed by another 6 years, over a decade left in limbo. Now picture this, being accused of a serious crime, yet waiting 11 years before your trial even begins.
length of delay, I think in this case that all the parties can reasonably agree that that is a tremendously long amount of time in this case, both between the alleged offense date and the indictment, and then between the indictment and when there was any activity on behalf of the state, whatever attempts those were in 2019, and then again between 2019 and the state's I just say weak attempts to find Mr. Hinojosa and 2023. Any of those taken individually are presumptively prejudicial, but taken together, it highlights the exact reason that these laws are on the books, Your Honor, and it prejudices Mr. Hinojosa's ability to put on a defense. I don't believe the state's efforts to show diligence in this case rise to the level of certainly they can't overcome the negligence that's apparent from the file. And for that reason, we ask for you to grant our motion to set aside the indictment.
All right. In your motion, it states that the case was dismissed July 28, 2017, and then re-indicted the same case on August 22nd, 2017. Why was it dismissed?
From my research into the JE system, it looks like it was originally supposed to be a theft, and the statute of limitations would have run on the theft by the date that it was the case was received from law enforcement by the DA's office. It was initially dismissed as a theft, but then indicted as a misapplication of fiduciary responsibility, which is within the statute there, Judge.
Okay.